HR professional, picture this scenario. You've got a solid employee. Let's call her Michaela. She's been with your company for 2 years, good performance reviews, reliable. Then suddenly, she starts missing deadlines, seems distracted in meetings, takes more sick days. Her manager pulls her aside and she says, "I'm sorry, I've just been really anxious lately. I can't seem to focus like I used to." The manager comes to you asking what to do. You think, okay, she's stressed. We all get stressed. So you advise the manager as a start to tell her to take a few personal days, maybe see if she can get some rest. She thanks them, takes the time off, comes back, but the performance issues continue. A month later, the manager decides to let her go for performance reasons without talking to you again. 3 months later, your CEO calls you into their office. There's a letter from an attorney on the desk. Michaela is suing the company for failure to accommodate her disability under the Americans with Disabilities Act. The demand letter? $40,000 in damages plus attorney's fees. Your CEO looks at you and asks, "How did this happen? I thought HR handled this correctly." Here's the thing. You did handle it the way many HR professionals would. You were compassionate, you gave her time off, you followed what seemed like the right process with the information you had. But there's a really tight gap between good HR practices and the legal requirements with vague complaints like Michaela's that can cost companies $40,000 or more. Hi, I'm Alex Castro, a Florida licensed labor and employment attorney with AXC Legal, located in Fort Lauderdale, Florida. Today, I want to educate you about mental health accommodations in the workplace. Remember, this is general information only. Every employment situation is unique and requires individualized evaluation. This scenario happens every single day across America. Business owners who think they're being compassionate, who think they're handling things the right way, get blindsided by ADA lawsuits because they don't understand one critical thing. When an employee mentions mental health struggles, you're not just having a casual conversation anymore. You may be receiving legal notice of a disability that requires accommodation. The mistake isn't being a bad employer. The mistake is not recognizing when mental health comments trigger your obligations under federal law. Here's what most miss about mental health in the ADA. The Americans with Disabilities Act doesn't just cover obvious physical disabilities like those with crutches and wheelchairs. It covers mental health conditions that substantially limit major life activities. Things like concentrating, thinking, sleeping, or working. And here's the part that catches employers and HR professionals off guard. You don't need an employee to say the magic words, "I need reasonable accommodation." Courts have consistently ruled that informal requests, casual comments, and even complaints about struggling can trigger your duty to engage in what's called the interactive process. Let me give you some real examples of statements that courts have found sufficient to put employers on notice. "I'm having panic attacks at work." "My depression is getting worse and affecting my job." "I need stress levels as low as possible." "My anxiety medication makes me drowsy in the mornings." Every single one of these statements has been the basis for ADA claims to go through when employers failed to respond appropriately. Let's talk numbers, because this is where it gets expensive fast. The average ADA settlement is around $40,000, but that's just the settlement. You're also paying for your own attorney. That's another $15,000 to $30,000 in legal fees. Then there's the employee's attorney's fees, which you have to pay if they win. Add in court costs, expert witnesses, and the time you're spending in depositions instead of running your business. I've seen cases where a simple accommodation request that could have been handled with a flexible schedule or work from home arrangement turned into six-figure lawsuits because the employer didn't recognize what was happening. Let me walk you through what should have happened in Michaela's case. Step 1. Acknowledge what she's told you and ask follow-up questions. "I appreciate you sharing this with me. What kind of support do you think would help you be successful in your role?" Step 2. Explore possible accommodations. For anxiety and panic attacks, common reasonable accommodations might include flexible start times to account for medication effects, permission to take short breaks when feeling overwhelmed, a quieter workspace away from high traffic areas, modified deadlines during particularly stressful periods, work from home options on high anxiety days. Step 3, document everything. Every conversation, every accommodation offered, every decision made. If it's not written down, it didn't happen. Step 4, implement the accommodation and follow up. How's it working? Does it need adjustment? Is it solving the problem? Here are the biggest mistakes I see companies make with mental health accommodations. Mistake number 1, ignoring the request entirely. "She didn't specifically ask for an accommodation, so I didn't think I had to do anything." Wrong. The law doesn't require magic words. Mistake number 2, assuming mental health issues aren't real disabilities. Depression, anxiety, PTSD, bipolar disorder, these are all recognized disabilities under the ADA when they substantially limit major life activities. Mistake number 3, jumping straight to termination when performance suffers. If an employee has disclosed a mental health condition affecting their work, you can't just fire them for performance issues without first exploring accommodations. Mistake number 4, violating confidentiality. Mental health information is medical information. You can't share it with other employees or discuss it in team meetings. Mistake number 5, assuming accommodations are too expensive or too disruptive. Most mental health accommodations cost nothing or very little to implement. Let me give you a simple system for handling these situations correctly. First, document your interactions. Every time an employee comes to you for help and mentions stress, anxiety, depression, or any mental health struggle, document it. Date, time, what was said, what you responded. Second, have a standard response ready. Something like, I appreciate you sharing this with me. Let's schedule a time to discuss what support might help you be successful in your role. In the meantime, here's our accommodation request form if it would be helpful. Third, train your managers. They need to know what comments trigger the interactive process and how to respond appropriately. A manager who says, just tough it out, or everyone gets stressed can create massive liability. Let's talk about what reasonable accommodations actually look like for mental health conditions. The good news is that most of them are low-cost or no-cost solutions. Flexible scheduling, allowing someone to start later if their medication makes mornings difficult or to leave early for therapy appointments. Modified break schedules, extra breaks for someone who needs to step away when feeling overwhelmed. Workspace modifications, a quieter workspace, permission to wear headphones, or a desk away from high traffic areas. Communication preferences. Some people with anxiety do better with written instructions rather than verbal ones, or advance notice of meetings. Temporarily reduced workloads. During particularly difficult periods, temporarily reducing responsibilities while the employee stabilizes. Work from home options. For some mental health conditions, working from home temporarily can significantly reduce symptoms. The key is that these accommodations must be effective. They have to actually help the employee perform their job, and they can't create an undue hardship for your business. Now, you're not required to provide any accommodation an employee requests. You can take your choice between effective accommodations and deny accommodations that would create significant difficulty or expense relative to your business size and resources. You can also deny accommodations that wouldn't be effective, or if the employee can't perform the essential functions of their job even with accommodation. But here's the critical part. You have to engage in the interactive process first. You can't just say no without exploring alternatives. Here's where employers and HR teams get into the most trouble. Terminating someone after they've disclosed a mental health condition. Even if the termination is for legitimate performance reasons, the timing makes it look retaliatory. If you need to terminate someone who has disclosed a mental health condition, you better have rock-solid documentation showing that the performance issues existed before the disclosure, you engaged in the interactive process in good faith, no reasonable accommodation could have solved the performance problems, and you followed your normal progressive discipline process. Without this documentation, even a legitimate termination can look like retaliation. Here's the bottom line. Preventing these lawsuits is infinitely cheaper than defending them. A comprehensive mental health accommodation policy and manager training might cost you a few $1,000s. A single ADA lawsuit can cost you 10 times that amount. Smart employers and HR teams are proactive. They train their managers to recognize accommodation requests. They have clear policies and procedures. They document everything. And when in doubt, they consult with employment counsel before making decisions. Beyond the legal requirements, there's a strong business case for handling mental health accommodations well. Employees who feel supported are more productive, more loyal, and less likely to leave. The cost of replacing a good employee far exceeds the cost of providing reasonable accommodations. Plus, with mental health awareness increasing, employees are way more likely to speak up about their needs. You can either be prepared to handle these conversations professionally, or you can be reactive and deal with the legal consequences. If you're facing a mental health accommodation situation, you may want to consult with a qualified employment attorney who can evaluate your specific circumstances. Don't wait until your CEO is holding a demand letter asking you how this happened. Review your policies, train your managers, and create systems for handling mental health accommodations properly. The employee who mentions they're struggling with anxiety isn't just sharing personal information. They may be starting a legal process that you need to handle correctly. You can either recommend proactive legal support to leadership now, or find yourself explaining later why the company is facing a $40,000 lawsuit. While HR is the heart and shield of a business and a company's first line of defense against costly legal exposures, you shouldn't be expected to know all the nuances of labor laws. Having a legal ally on your side ensures you have the right protections in place. If you need any help with this topic, just click the link below. Thanks for watching.